SJC-12318, Commonwealth versus Cristian Rodriguez.
Good morning, Mr. Reardon.
Good morning, Your Honors. Theodore Reardon on behalf of the defendant, Cristian Rodriguez. In 1865, this court decided the case of Barber versus Merriam. The court held that it was well established at that point that a statement to a physician for purposes of diagnosis or treatment was a hearsay exception and could be admitted substantively. That was a medical malpractice case. That holding was subsequently implied in a CMP case in Michaud and in the criminal context in Comtois. And so the present state is that the Commonwealth routinely admits statements of alleged victims that were given for purposes of diagnosis or treatment. The issue before this court today is whether or not the statements of a defendant that are likewise given for diagnosis or treatment are admissible substantively. And the answer is yes. The case law that I cited makes no distinction between criminal defendants and others, and likewise, the analysis would apply with equal force.
Is there a
Oh, go ahead.
I'm sorry. Is there a difference, though, between a statement made for diagnosis or treatment and a statement made in the context of trying to determine whether somebody is competent or criminally responsible for their actions?
I don't think so, no. In both cases, it's for purposes of diagnosis, and the doctor, in this case, Dr. Rosemarin, clearly gave his diagnosis. In addition to the case law, we also have the Mass Guide of Evidence, Rule 8034, which is not limited to physicians, but says that statements for diagnosis or treatment are likewise admissible under that rule. And likewise, that makes no distinction between criminal defendants and others.
So, counsel, really, are you, in essence, arguing that there should be no difference between how we treat medical diagnoses of the body and medical diagnoses of the mind?
Yes. Yes. So, in this particular...
What about, one of the underpinnings of hearsay exceptions is reliability.
Yes.
Right? And how do you address the argument that when someone goes to the physician, whether it's a mental illness or a physical illness, and they say, I'm hearing voices or my knee hurts, that we say that's reliable because you're not going to lie to your physician because you want treatment. And I get your diagnosis argument. I agree with that. But here, the reliability is different because it's in the forensic context, and the only reason you're being interviewed is to see what was your mental state, perhaps to see whether you're not criminally responsible. So how do you address that reliability issue?
Three responses to that. I want to cite to the Barber case itself. It has a very interesting quote on this issue, where the court was concerned that a plaintiff, medical malpractice plaintiff, may have an incentive to exaggerate or perhaps lie to the doctor. And this is what the court said. It's kind of old language. To the argument against their competency, founded on the danger of deception and fraud, the answer is that such representations are competent only when made to a person of science and medical knowledge who has the means and opportunity of observing and ascertaining whether the statements and declarations correspond with the condition and appearance of the persons making them and the present existing symptoms which the eye of experience and skill may discover. So the court in 1865 was concerned with that very issue about an incentive to not be truthful to the doctor. And the court said it's up to the doctor to weed out between what the person's saying and what they're observing.
Nature of the examination in Barbara.
It was the nature of the examination?
Yeah, it was something with some statement was made to the doctor that you say the court held in 1865 fell within the hearsay exception for the statements for the purpose of the medical diagnosis and treatment.
Yes, well, in that case, it was the person had changed doctors, and there was a question of whether or not there was a change in the condition when they changed doctors.
So I guess the issue is whether was it a treating doctor or an expert witness?
That's what I'm trying to ask you. Thank you. Was in 1865, was the Med-Mal case about whether you could enable an expert in a criminal case to testify as a forensic expert?
No, and it was admittedly a treating doctor in question here.
So when Justice Graziano made the point about the hearsay exceptions mitigate certain infirmities of hearsay, here we're talking about lack of sincerity, because I don't know about anybody else, but the last person in the world I'm lying to is my doctor. And that's the reason behind the hearsay exception. When you're dealing with, when we're trying to get information to an expert in a forensic context to enable them to be able to testify as an expert, psychiatrists, psychologists in the field, they have all of these data and studies and best practices to try and mitigate against the danger of meandering. So in other words, the concern is that you're not going to lie to your doctor who's trying to diagnose and treat you, but we better be really concerned about somebody who's saying that they're not criminally responsible, that they got diminished capacity, that they might lie. So the whole point of the hearsay exception for statements for the purpose of medical diagnosis and treatment don't apply when you're dealing with being able to enable an expert to be able to testify and have the information from the defendant. And the 16L letter that you sent yesterday or the day before exactly makes that point. The defendant's making that exact point.
Okay. One of the, I think,
In other words, the case you sent yesterday makes the point against you.
I don't think so. Let me back up.
Yeah.
One of the things you indicated just now was for diagnosis and treatment. But the case law and 8034 say very clear. It says or, diagnosis or treatment. So it's not, it doesn't have to be a treating doctor to whom the statement is made. It can be for someone to whom a diagnosis is made. And then as to the case that I sent in yesterday, I think that is helpful to me. And the reason being is this. In that case, the Commonwealth sent the alleged victim for an examination. It was clearly a forensic examination. And the court in that case said, well, because the place where the doctor works is also offers treatment, then it was okay. But I think the bottom line is that this really was a person sent for a forensic examination.
Well, no, in Judge Rubin's opinion, the judge says that the doctor wants to get the medical history so he can figure out how to provide some guidance on what I need to think about in terms of ordering additional testing. And the defense attorney argues that the statements were made in order to be able to enable the expert to testify, so it shouldn't qualify.
Well, I think earlier in the decision, I think there's more to that case than meets the eye, because the defense is clearly making the point that this person was sent there by the Commonwealth for a forensic examination. That was the purpose in which it was sent.
Which they're concerned about.
I'm sorry?
Which the defendant was concerned about.
Right, right.
Mr. Reardon, you raised a really interesting issue. And when I asked you about the reliability, you told me there are 2 reasons why it's reliable, and I don't know if we got the 2 reasons. I want to give you the opportunity to tell me those 2 reasons.
Oh, 3.
3 reasons, okay.
So first,
I'm writing down.
First is the passage from Barbara.
Yep.
The second thing is the statement, the claim that the defendant has a reason to fabricate or exaggerate. Well, you could say the same thing about alleged victims. They could have some kind of
Well, they're
bad
kind of in
motive.
different positions, aren't they?
I'm sorry?
They're really in different positions.
Well,
Nobody's coming after the victim with a life sentence possibility.
Well, most of the victim cases come twice, as you pronounce it in Arana. They're children who are sent to a treating physician for help, right?
Yes, but it's not limited to that. And my point is that you could have a victim who has some motive to, against the defendant, or could want to exaggerate.
But
the
I guess
symptoms.
we don't have any cases of victims who have been injured who are sent to an expert witness. It's usually victims who are injured who go to a treating physician and then comes in for that purpose. My understanding, at least.
Yes, but again, I think the same reasoning applies, that they could have a motive when they go.
Sure. No, okay. And what's reason number 3, Mr. Reed?
And the reason number 3 is that, the reason number 3 was the case I sent yesterday, that I believe that supports me.
Okay.
If I can turn you to, let's imagine that you don't persuade us that we should, in my view, change our case law on that. There was arguably some ambiguity about what the judge, at least until his closing instructions, said about the admissibility of the Whittier notes. Help me to understand better your argument that the judge's instructions, especially what he said to Dr. Rosemarin, would have effectively told the jury that they should not consider what Mr. Rodriguez said when he was at Whittier before the killing with regard to its admission for its truth.
Yes, but as I do that, let me also address also the significance of the Whittier records. The Whittier records, it's all background, past mental health history. The bottom line is that, frankly, none of that's worth anything unless there's evidence about what the defendant was experiencing at the time of this incident. In particular, his statements to Dr. Rosemarin that he was experiencing a hallucination and that the hallucination told him to hit Mr. Harris.
Well, was there any, in the Whittier notes, will we find anything that speaks of hallucinations?
Yeah, about hallucinations, and yes, but again, they all predate the incident, and so.
But I thought Dr. Kelly's primary argument was the only evidence we have of any hallucinations or of hearing voices occurred after the killing and were self-serving and therefore are not credible. And if the Whittier notes, which occurred before the killing, reflected him hearing voices or hallucinations, they arguably could bear on the evaluation of Dr. Kelly's opinion.
I believe what Dr. Kelly said was that the only evidence in the Whittier records of him having hallucinations are the defendant's statements. I might be mistaken, but I'm.
So he did testify to that for their truth. I mean, when Dr. Kelly made reference to the Whittier statements, he was effectively saying that they're appropriate to consider, but they should be discounted because they all came from the defendant, even though they occurred before the killing.
Well, he said they're not worthwhile because they came from the defendant. There is no evidence. He was basically saying of hallucinations because the only evidence of them was the defendant's statements. So, but addressing the question you asked, at the beginning of Dr. Rosemarin's testimony, there was a limiting instruction given about the defendant's statements not being admitted substantively, not just Dr. Rosemarin, but in general. And then the defense counsel got into the Whittier records with Dr. Rosemarin, and Dr. Rosemarin, when certain things were in the records, the prosecutor objected in saying, well, what's the basis for, that entry in the record? To which Dr. Rosemarin said the defendant, his statements. And then there was a discussion with the judge about an ongoing limiting instruction, and the judge instructed defense attorney to make sure that she elicited the basis for each statement in the Whittier records. So in that context, it was very clear that any statements in the Whittier records could not be considered to be truthful if they came from the defendant. Fast forward to the closing instruction, the final charge, the judge did not repeat that as to the Whittier records, but when the Whittier records were admitted into evidence, it was quite clear the context in which they could be considered.
I mean, his closing instructions, he spoke of only the 3 post-killing doctors.
Yes.
Do we have any evidence as to what occurred when he was a child in the Dominican Republic?
His own statements, that he that he fell out of a tree, I believe it was, and that since then he has had cognitive issues and whatnot. But there was evidence, but it was from him.
Okay, do we have any, now the trial's over, do we have any records that indicates that in fact happened?
I can tell you that I've tried to get the records, and a trial counsel tried to get the records, including contacting people in the Dominican Republic, and there's a communication issue, or they don't keep good records or whatnot, but we haven't been able to get anything.
What about, have you pursued through motions for, I know you had a motion for new trial in here, but any additional testing of the defendant?
No.
At this point?
No.
Now, one of the issues that's a little different in this case is that Judge Muse allowed what the defendant said to the expert for limited purposes, basically to be able to understand the basis for the opinion. which is not a law. And it seemed to confuse everything. I know you didn't brief it, but did that ruling confuse issues for the jury here?
I actually did brief that issue, and I said that that actually put, I'm sorry?
Go ahead, I apologize.
My argument that I made in the brief was that that actually put the defendant in a worse position.
Right.
Because if that hadn't happened, the expert would have stated his opinion, and
You did raise it.
the expert would have stated his opinion, the jury wouldn't know what the basis was, and there wouldn't be any criticism of, the jury not accepting what the defendant said is true.
And the judge's conversation or questions of the expert.
Yes,
Like,
yes.
Are you saying that you know what happened, that whole dialogue?
Right.
Which couldn't have been good for the jury.
Exactly.
To hear. So the sort of allowing in the basis, which we don't do, really made it a little bit difficult because you had to have this instruction.
Yes,
And you wouldn't have otherwise needed it.
right, yes.
So you're better off with the old rule.
Yes, yeah, right. Well, let me be clear about that I'm not asking the court to overturn the Nadi case law that talks about...
I'm not taking to the, because you're very, I commend you, because what you've done is taken an area that the 803.4 and trying to apply it, not to say we should overturn it, but say this has not been decided by this court.
Exactly, yes.
As we didn't do in Hamey and all those juvenile and the Penadosi case.
Right, exactly. If there are no other questions, Your Honors.
Okay, thank you.
Thank you.
Ms. Leary.
Good morning. May it please the court, Catherine Leary on behalf of the Commonwealth. With me today is the trial prosecutor, Ian Pollenbaum. Commonwealth respectfully requests the court affirm the defendant's conviction for first-degree murder and decline to exercise its powers under 33E. First, the defendant got a benefit for which he was not entitled to, and one that he requested through his counsel was to have the basis of the expert's opinions testified to on direct examination.
I'm not sure it ended up being much of a benefit. It seemed to have been harmful, at least the way it played out in this case.
Well, it's a cold record. It's a cold trial transcript, so I don't know if it's necessarily fair to say that based on reading a cold trial transcript. And where defense counsel asked for this and agreed for this instruction, which this court has said in Rutowski at 459 Mass 794 800, that when a defendant's statements come in through an expert witness as the basis, it's a proper instruction to limit the jury's consideration of them for the basis of that opinion and not for their truth. And so there could be a time when, if the Commonwealth chooses to open the door on cross-examination, the defendant's statements come in on redirect examination. And so the jury would be almost in the same position where there could be, I guess, this confusion, but I don't necessarily think there was this confusion there, especially where the judge was very clear in his final instructions regarding...
Was there an objection to the limited instruction in the final instruction?
No, there was not. And after the first initial limiting instruction, as Dr. Rosemarian began to testify about the defendant's personal history that he recounted during his forensic interview, after the limiting instruction, the judge called a sidebar and said, do you have any objection? Do I need to add anything? And defense counsel said no. And I think it was clear based on that instruction, the judge was talking about, refer back to Dr. Klein's testimony from the day before, and referred to Dr. Rosemarian's testimony, and that this was limited to when a defendant talks to a forensic psychologist for the purpose of a court evaluation that's going to be used in court.
What's the name of the case? I'm sorry, 459 Mass
It's
794?
Rutowski, R-U-T-K-O-W-S-K-I, and it's 459 Mass 794 in that site about the limiting instructions on page 800.
So what do we do with regard to Dr. Rosemarin's testimony relying upon the Whittier notes? Those are the ones that I find most troubling.
Your Honor, I think it's clear based on the timing of the limiting instructions and the final charge that the jury's full substantive use of the defendant's statements in those about his hallucinations and hearing voices, which in the records, it was at the group meetings that came out before the murder. I think it's clear that the timing of the limiting instructions and how that they were stated, the Whittier medical records were admissible for their full substantive value. And when the prosecutor, if you look at the prosecutor's objection, I think the prosecutor was just trying to clarify, and the court was trying to clarify that if you're referring to something in the defendant's records, it has to be the defendant's statements about his symptoms. It can't be just a statement in the medical records from somebody else that's based on hearsay. And I think in context, that's what the judge was trying to clarify, maybe not the most artful way, but I don't think it was clear, or the jury could take from that conversation, that they couldn't consider these statements in the Whittier Street medical records for their substantive value. And I would also point to the fact that while the jury could consider these statements, and I don't think that was taken away from them, the defendant's girlfriend testified on his behalf that he had a history of hearing voices, and that on the night of the murder, she talked to him and he seemed paranoid and not right. So there was other evidence of this before the jury.
It's just not as good to argue to the jury that, the girlfriend said it as opposed to in a medical record.
But the girlfriend, right, because she has maybe ulterior motivations, which the prosecutor did highlight, but those records were in evidence, and I just don't think, in context of this whole trial, that what the judge in the conversation at sidebar or in front of the jury could really take these out of their consideration. Trials, imperfect things happen. Could things have been done more artfully upon reflection? Clearly, and the judge's final instruction shows that he was clearly trying to be very specific. And the point of, keep not using the full substantive value of the defendant's statements to his forensic experts is partially to protect the defendant, because they'll have admissions of guilt and the jury can't use that as substantive evidence, which is part of the Commonwealth's pushing for such a limiting instruction, as well as the fact that, going to Justice Gaziano's question about reliability, I think these statements are inherently unreliable because they're made for the purpose of court, whether it's a competency evaluation ordered by the court or the defense putting his own mental state at issue. I don't think this is a classical statement for medical treatment or diagnosis, because when you're going to a treating...
Well, it's certainly for diagnosis.
Well,
diagnosis is what's wrong with you, and Dr. Ross-Marin saying this is what's wrong with him.
Well, I think you have to look...
Whether we should expand this exception to encompass this is a different story, but I don't think you can argue it's not for diagnosis.
I think when you look at the underpinning of Rule 803, Section 4, and statements for treatment or diagnosis, yes, diagnosis is an ancillary result of these competency evaluations or criminal responsibility evaluations. The purpose of why 803 statements under 803 Section 4 are admissible is because you want to be truthful because you want to get the correct diagnosis to get the treatment. Whereas here, yes, you're getting a diagnosis, but it's for a legal purpose to benefit you. So, and I think when you look at the rule of hearsay and why it's inadmissible, it's because it's unreliable, and hearsay exceptions are allowed because...
On the face of 803.4, it does say diagnosis or treatment.
Correct, and I think in that context, when it's for diagnosis, I think when you're looking at the spirit of the hearsay exception and the policy rationale behind it, which is sound, you're getting statements so a doctor can diagnose you. Generally, treatment's going to follow from diagnosis. And while that might happen as a result of these evaluations, that's not the primary purpose of it. And I think you have to look at the real incentive behind the declarant in these cases, especially when you're talking to a forensic evaluator for the purpose of expert testimony.
So you're saying the rule should more properly read diagnosis for purposes of treatment versus diagnosis for purpose of a forensic evaluation?
I think that would probably be more clear. I don't think the fact that it has an or in the rule, which is based off of our case law, I think when you look at the policy rationale behind the case law, as I've kind of gone in circles articulating, I don't think it's diagnosis and that's it. I mean, that would make it so.
What about the victim cases? I think it's Comtois or another one I read where there's an allegation of child sexual assault and the mother does two things: contacts the police, and then has the child taken to a physician to see if there's evidence of sexual assault.
Yes, Your Honor. And I think those cases where you have victims who go to a treatment facility and are treated by a doctor or make statements, while yes, they do have the other purpose of perhaps they're going to get testified to. Victims are in a different situation in the fact that, as the doctor in Michigalansky, which was cited in my brother's 16L letter, said, yes, that's a purpose, but my real independent purpose is to do an evaluation to ensure what type of treatment and test, because if the child has a sexually transmitted disease, I need to know to be able to treat that. So there's an independent treatment part of those statements that's used, and it's not solely for this purpose. And while there could be a possibility where a victim could, maybe not a child, you never know, but a victim could make a self-serving statement. The same could be true for another exception would be like excited utterances, where the judge has to determine that the indicators of reliability are present. They don't have to make a credibility determination that the person is credible. It's because the circumstances are presumptively reliable based on the circumstances. The declarant in a 911 call, for example, finds himself in, or a victim talking to a treating physician.
What did Dr. Kelly, when we read Dr. Kelly's testimony, what did he do with regard to the Whittier records?
So he found that the only evidence of the defendant's hallucinations or hearing voices was when he was talking about it in the group setting with other people, and that each time he talked about, and he didn't find it credible because each time he had talked about hearing voices, just before that or just after that, he had gone and seen a psychiatrist and never mentioned it, and didn't say anything about it to a mental health doctor. But in these group, more treatment settings, because it was for alcohol and drug use and some mental health stuff that goes along with it, but it wasn't in the context of my psychiatric doctor. I'm going to tell them I'm hearing these voices. I'm hearing other people in these group treatment settings saying this, and I'm bouncing off of that. So he didn't find that credible. He also didn't find the defendant's statements credible about how his version of how the incident came about as an acute psychotic incident. He didn't find that the defendant was decompensating the way a normal paranoid schizophrenic would at his age. So among other things, besides the defendant's, his actions before, like during and after the murder, running out of the apartment, hiding the bat in a trash can, which he knew would be taken out at some point very soon, stopping when he recognized somebody on the street who would maybe recognize him from the store, and then running, and then starting his criminal responsibility defense the next morning when he stuck his head in the toilet he had defecated in, and then stopped immediately when he was told to do so, which was not consistent with somebody in a delusional system. If the court has no further questions, I'm happy to rest on my brief.
All right, thank you.
Thank you.